to 21 of the Code of Civil Procedure. Is it audible, Mr. Vikas? Hello? Hello? Mr. Vikas? Is it audible? Okay. Okay. I have been telling every time that for a lawyer practicing on civil side and for a judicial officer presiding over a civil court, it is compulsory that they should be well versed with the provisions of the Civil Procedure Code. And also, they must have a thorough knowledge of the civil rules of practice framed by the respective state governments in consultation with the High Court, respective High Courts. In addition to that, they should also be well conversant with the provisions of the Civil Codes Act prevailing in the state. It is only when these three statutes are well informed or get adequate knowledge, one will be able to succeed as a good civil lawyer, and a judicial officer will be able to decide the cases by following the proper procedure. Therefore, a thorough knowledge of the Civil Procedure Code, Civil Rules of Practice, and Civil Codes Act is a must. Suits may be of different types. They may relate to movable properties, immobile properties, or they may be based on contracts or torts. One of the important questions that confronts an advocate who wants to file a suit, or a question that confronts a judicial officer while deciding whether the court in which he is presiding has got jurisdiction or not, is the law relating to place of suing, which is covered from section 15 to section 21 of the Civil Procedure Code. This is a very, very important chapter in the Civil Procedure Code, because the place of suing that determines, it is the place of suing that determines the jurisdiction of the court to entertain, deal with, and to decide the case. So even to entertain or admit a suit, the court must have the jurisdiction. And it can decide the case only when it has got jurisdiction. Therefore, the provisions of section 15 to 21 are very important. Under law, different courts have been empowered to decide different types of suits. Certain courts have no jurisdiction to entertain certain suits and decide. For example, the small cause courts have no jurisdiction to deal with the cases in respect of an immobile property. Likewise, the disputes relating to marriage, divorce, maintenance, etc., will have to be decided by entertained and decided by the family courts wherever the family courts are established, and not by the regular civil courts. The matter relating to industrial disputes are to be decided by the industrial tribunal. Labor disputes, labor court. So on and so forth. So the different courts have been conferred with the jurisdiction to deal with different types of litigations. If the court has no jurisdiction over the subject matter of this suit, there is an inherent lack of jurisdiction, and a decree passed by such court is a nullity. This is an established principle of law. And even if there is such a judgment and decree passed by a court which has no jurisdiction over the subject matter, can be challenged even during the execution proceedings. This principle has been laid down in the decision of the Honorable Supreme Court reported in AIR 2020, Supreme Court 3670, EXL Carriers and another versus Frank of Aviation Services Private Limited. We will come to that later. Now, coming to the subject matter of the day. Section 15 of the Code of Civil Procedure says, court in which suits to be instituted. It reads like this. Every suit shall be instituted in the court of the lowest grade competent to try. Lowest grade competent to try. What do we mean by this? In order to better understand this, it is necessary to go through the provisions of the Civil Courts Act. It is the Civil Courts Act which decides, which enumerates the different types of civil courts, their powers and jurisdiction. So, the lowest court competent to try means the suit will have to be instituted before the court which is competent, number one. Number two, that must be the lowest court in the grade, because the higher court will have an appellate jurisdiction. The word competent used in section 15 refers to the jurisdiction of the court. The object of section 15 is, number one, to avoid overcrowding of cases in higher courts. What do you mean by this? Supposing this provision is not there and the choice of filing the suit is left to the parties, they may think of filing the cases in the courts which are nearer to them, and in such an event, the appellate courts will be heavily crowded with litigation which makes them impossible to decide or difficult to decide. Number one. Number two, for the convenience of the parties and witnesses who may be examined in the case. Supposing a suit has to be filed in a mafusal area, and that is the court which is the competent court to try of a lowest grade. And if the suit is filed in the district headquarters, it will be very inconvenient for the parties to travel between the mafusal area and the court and the place where the court is situated. It will be difficult for the parties to take the witnesses also to them without incurring unnecessary expenses and other inconveniences. Therefore, the main object of section 15 of the Act is, number one, to avoid overcrowding of cases before the appellate courts. Number two, for the convenience of the parties and witnesses. When we are talking of section 15, we come across the word suit. In this context, it is necessary to refer to the provisions of section 726 of the Civil Procedure Code also, which says that every suit shall commence by presentation of a plaint. That means the suit will commence by presenting a plaint as required under Order 7 of the Civil Procedure Code. So, the reading of section 15 says that every plaint shall be presented before the court of the lowest grade which is competent to try. Section 15 enacts only a rule of procedure. It does not affect the jurisdiction of the higher court to try the suit entertainable by the lower courts. What do you mean by this? The meaning is, the higher court will have jurisdiction to entertain the suits of all civil nature. A suit which could be filed before a civil judge can also be filed before a civil judge senior division. But the point is, when the lowest court of a competent jurisdiction is the civil judge court, that suit should not be filed before the civil judge senior division court because that becomes an appellate court. And if that is allowed, the appellate court will be heavily crowded with such litigations. Then what is the option open to the appellate court? That is higher court. The higher court may, in its discretion, return the plaint for presentation to the proper court as contemplated under Order 7, Rule 10. Of course, it will not bar the appellate court, that is the civil judge senior division, from trying that suit, because the civil judge senior division under the Civil Courts Act is competent to try all suits of civil nature. But if the jurisdiction to try that case is falling under the civil judge court, the propriety demands that the civil judge senior division court will have to return the plaint for presentation to the proper court. So when we are talking of presentation of a suit before the competent court of a lowest grade, we mean that we are talking about the jurisdiction. So when we are talking about the jurisdiction, two aspects come before our mind. One is the pecuniary jurisdiction, another one is the territorial jurisdiction. The territorial jurisdiction of the court is on the basis of the area where the dispute or transaction had taken place or the property is situated. Meaning thereby, the court within whose jurisdiction the property in respect of which a suit is filed, or the area within which the transaction in question has taken place, it is only that court which is situated within that particular area, within that particular territory, has got territorial jurisdiction. So the territorial jurisdiction is the jurisdiction that will be decided on the basis of the place where the property is situated, or the place where, or the area where the transaction has taken place. Then comes the pecuniary jurisdiction. Pecuniary jurisdiction of a court is based on the monetary value of the subject matter of the suit. So if the monetary value or the subject matter of the suit in terms of money is up to a particular limit, then a particular court only will have a jurisdiction to entertain as a court of original jurisdiction. Of course, I am not aware of the other states. So far as Karnataka state is concerned, I can only say that as per the Karnataka Civil Courts Act, the civil judge court, that is the first court in the hierarchy, first court from the in the ascending order, from the as far as the civil court is concerned, is having a pecuniary jurisdiction up to rupees 5 lakhs. And the civil judge senior division, as a court of original jurisdiction, can entertain the original suits of 5 lakhs and 5 lakhs, above 5 lakhs, unlimited. So the pecuniary jurisdiction of a civil court depends upon the value of the subject matter of the suit, or in terms of money. These are the two aspects which are to be kept in mind when we are talking about Section 15 of the Civil Procedure Code. In a judgment of the Honorable High Court of Honorable Supreme Court, reported in AIR 1969 Supreme Court, page 823, it is held, jurisdiction means power to decide and pass order sought for. In another judgment of the Supreme Court reported in 2007, Part 12, Scale 130, Mohan Kumar and Nair versus Vijay Kumar and Nair, it is stated that the plaintiff, being the dominus litis, can file a suit only at one place, one or the other place specified in the CPC, and not at all places. Meaning thereby, even though more than one court has got jurisdiction to try the particular dispute, the plaintiff, though he is a dominus litis, he can file a suit in only one court and not in all the places. In 1964, Part 2, Mysore Law Journal, page 348, it is held, Section 15 applies to all suits, including suits which could be tried under Order 37, that is summary suits. Then how to, insofar as the pecuniary jurisdiction is concerned, it depends upon the valuation that is made. In AIR 1987, Supreme Court, page 1947, Srimati Nandida Bose versus Ratanlal, while dealing with Section 15, the Honorable Supreme Court has held valuation for the purpose of jurisdiction. The valuation for the purpose of suit, for the suit, depends chiefly upon the relief that is sought by the plaintiff, and the valuation therein determines the court in which the suit could be presented. Supposing I say that the civil judge court has got jurisdiction, pecuniary jurisdiction up to 5 lakhs. It depends upon the valuation of the suit that is made. And that it is that valuation that determines whether the suit has to be filed before the civil judge court or before the civil judge senior division court. The word competent, which is used in section 15, refers to, as I have already told, the jurisdiction of the court. This is so far as section 15 is concerned. There is one more judgment concerning section 15 only, reported in AIR 1952 Bombay, 55 Bombay, page 55. Quote, where a suit which ought to have been instituted before a higher court, instead of before the lower court, instituted before the lower court, the subsequent enhancement of the pecuniary jurisdiction of the lower grade court so as to cover the suit instituted before the higher court, that will not cure the defect. Now we will move on to section 16. Section 16 of the Civil Procedure Code, the caption reads as under: suits to be instituted where subject matter is situated. Subject matter is situated. This is a very important section which should be kept in mind whenever a suit in respect of an immovable property has to be filed. What does this section say? Subject to the pecuniary or other limitations prescribed by any law. So pecuniary jurisdiction will have to be kept in mind while deciding the court which has got jurisdiction to entertain a suit in respect of the properties mentioned in section 16. Subject to the pecuniary or other limitations prescribed by any law. Suits. A. For the recovery of immovable property with or without rent or profits. It could be a suit for declaration. It could be a suit for injunction. It could be a suit for declaration in possession. It could be a suit for possession. It could be whatever it is. So if it is in respect of, or if it is for the recovery of a eviction of a person from the premises and also for rent, then section 16(1) will have to be looked into. B. For partition of immovable property. Goes without saying. C. For foreclosure, sale, or redemption in the case of a mortgage of or charge upon immovable property. Section 58 of the Transfer of Property Act defines what a mortgage is. Mortgage means creation of an interest in an immovable property as a security for the debt advanced. So there will be a mortgagor who mortgages the property and offers his property as a security to the mortgagee who advances money to the mortgagor. Therefore, there will be a mortgage deed, and as per the mortgage deed, if either the mortgagor or the mortgagee will have to file a suit, that should be that suit will be only in respect of the mortgaged property, which is an immovable property. Therefore, the suit for foreclosure, sale, or redemption in the case of a mortgage of or charge, section 100 of the Transfer of Property Act speaks of creation of a charge of an immovable property, even that is also covered under section 16. D. For the determination of any other rights to or interest in immovable property. Determination of any right or interest in the immovable property. E. For compensation for wrong to immovable property. This we will discuss later. F. For the recovery of a movable property actually under restraint or attachment. So if in cases coming under any of these five circumstances, A to F, of section 16 of the Transfer of Property Act, the law says that suit shall be instituted in the court within the local limits of whose jurisdiction the property is situated. Now let us examine the section 16. Shall be instituted in the court within the local limits of whose jurisdiction the property is situated. Now from A to F we have seen that the suit is only in respect of an immovable property, of course, except F. I am coming to that little later. Subsection A to subsection E are the situations which cover suits which are filed in respect of an immovable property. Therefore, such suits will have to be filed before the court within whose jurisdiction that property is situated, that immovable property is situated. So, if it is a suit for injunction in respect of an immovable property, if it is a suit for declaration and title, if it is a suit for declaration and possession, if it is a suit for mere possession, if it is a suit for specific performance of the contract, or if it is a suit in respect of any wrong done to the immovable property, all these suits will have to be filed before a court within whose jurisdiction, within whose territory the property is situated. So the law is very clear. There is a proviso attached to this. Then before that, what does F says? For the recovery of a movable property actually under distraint. What do you mean by distraint? Distraint means the seizure of some movable property in order to obtain payment of money or seizure of an immovable property. Supposing X is liable, X is due in a certain sum of money to Y. Y files a suit against, Y has to file a suit against, Y files a suit, Y, the property has been attached or it is under distraint. It is published for sale and it is a movable property. Then the place where that movable property is situated, though the property may be belonging to X, which was in some place called A, but after distraint, that is after attachment, if that property is in place B, then though it is a movable property, the court which is having jurisdiction over the area where the movable property, at B where the movable property is placed, that court will have the jurisdiction. That is how section 16 clause F will have to be interpreted. But there is a proviso to that. What is that proviso? That a suit to obtain relief respecting or compensation for wrong to immovable property held by or on behalf of the defendant may, where the relief sought can be entirely obtained through his personal obedience, be instituted either in the court within the local limits of whose jurisdiction the property is situated, or in the court within the local limits of whose jurisdiction the defendant actually and voluntarily resides or carries on business or personally works for gain. Now, before understanding this, we should understand what do we mean by a wrong done to the immovable property. That is mentioned in section 16, subsection 1E. For compensation for wrong to immovable property, it can be understood as tortious acts affecting the immovable property. Example, trespass, damage caused to the property on account of a trespass. I'm not talking about Indian Penal Code, the definition of the word trespass in Indian Penal Code. I am talking about the law of torts. Nuisance, trespass, nuisance, infringement of easement. These are all some of the examples which can be brought under the heading of wrong to immovable property. How? Supposing I am the owner of an immovable property where I have raised some standing crop. If the defendant enters upon my property unauthorizedly and causes damage to my property, as a result of that, a wrong has been committed to my property, which was on an immovable property, that is my land, as a result of which I sustained loss. Number one. Number two, nuisance. Supposing I am the owner of a house. My neighbor allows his dirty water from his house into my house or into my area and thereby cause a foul smell in my property. One of the examples of nuisance. Nuisance could be any example for that matter. Nuisance. As a result of which I have suffered there are some health results and I have suffered some loss. Nuisance. Example I'm telling, that's all raw examples. These are all raw examples. Infringement of easement. I have a right to enter upon the property of X in order to reach my property, and that is an easementary right that is created. If the defendant prevents me from entering upon that property, his property, for the purpose of enjoyment of my property, then also it comes under the heading of wrong to immovable property, for which I am entitled for some loss, a compensation. Because I suffered loss, I am entitled for compensation. So in all such cases, I can give umpteen number of examples to cover this clause E of section 16 of the Civil Procedure Code. So any loss that is sustained by the plaintiff on account of a wrong done by another person to the immovable property is also a suit coming under section 16, which could be filed where the property is situated. But the proviso to section 16 gives an exception to that. What is that exception? Let us read the proviso again. Provided that a suit to obtain relief respecting or compensation for wrong to immovable property held by or on behalf of the defendant may, where the relief sought can be entirely obtained through his personal obedience. What do you mean by personal obedience? That is, without resorting to proceed against the immovable property of the defendant, either through attachment or whatever it is, if I am able to get compensation from the defendant by proceeding against him personally, that is called as personal obedience. How? It could be either under arrest before judgment, as contemplated in Order 38 Rule 1 to 4. It could be an attachment before judgment, as contemplated under Order 38 Rule 5, in whatever manner that I could feel. So I could find it proper. So where I can get the compensation through his personal obedience, or be instituted either in the court within the local limits of whose jurisdiction the property is situated. Supposing the defendant is having property in a place X, but he is residing in a place Y. Area Y, the court having jurisdiction, the court having jurisdiction of the area where Y is situated is different from the court which has got jurisdiction over the property where that is X property. So I can choose to file a suit either at the place X before that court where the property is situated, or I can file a suit before the court within whose jurisdiction the defendant is residing, where I can secure the personal obedience, where I can get compensation through the personal obedience of the defendant. So this is an exception to the general rule found in section 16, a proviso. Explanation in this section: property means property situated in India. So it cannot extend to other properties. So the proviso is an exception to the main part of section 16. It cannot be interpreted to enlarge the scope of the principal section 16. The proviso is applicable if the suit falls within one of the categories specified in the main part of the section, and the relief sought could be entirely obtained by personal obedience of the defendant. This principle has been laid down in the decision of the Honorable Supreme Court, reported in AIR 2005, Supreme Court, page 4446. Am I audible, Mr. Vikas? Mr. Vikas, sir.
Yes, sir. Yes, sir.
Am I audible?
Yes, sir.
The personal obedience of the defendant can be secured only if the defendant resides within the local limits of the jurisdiction of the court or carries on business within the local limits. If the defendant does not comply with the judgment, he can be arrested and committed and be committed to jail, or that his goods can be attached until he complies with the order of the court. That means to say, when I want to file a suit, when I do not want to file a suit where the property is situated in respect of a suit where I am claiming compensation for the wrong done to the immovable property, and if I want to file a suit in the place where the defendant is residing personally or is working for gain where by running a business, then I can secure the compliance of the decree in the event of my success through personal obedience, that is either by causing the arrest of the defendant or by getting the movable properties of the defendant attached and sold. So that is the meaning of saying where the plaintiff is able to obtain the execution of the decree through personal obedience. So this is so far as section 16 of the act is concerned, of the code is concerned. Yes. Now we'll move on to section 17. Suits for immovable properties situated within the jurisdiction of different courts. Where a suit is to obtain relief respecting or compensation for wrong to immovable property situated within the jurisdiction of different courts, the suit may be instituted in any court within the local limits of whose jurisdiction any portion of the property is situated, provided that in respect of the value of the subject matter of the suit, the entire claim is cognizable by such court. What do you mean by this? Supposing I want to file a suit for partition against my brothers and sisters. The property belonging to the family is spread over in different places. It may be in Bangalore, it may be in Mysore, it may be in Mandya, or it may be in so many other places situated. And all the properties will have to be included in a suit for partition. I cannot file different suits in different places where the properties are situated. Because otherwise I may have to file a suit in Bangalore in respect of properties situated at Bangalore, and another suit in Mandya in respect of the properties situated at Mandya, and a third suit in Mysore where the properties are situated at Mysore. So that not only causes inconvenience to the parties, both by plaintiff as well as defendant, but also unnecessary litigation expenses. In order to solve such a situation, Section 17 has been enacted. How it works out so far as Section 17 is concerned? As per Section 17, where there are properties situated over different areas which are within the jurisdiction of different courts, then suit can be filed before any one of the court, in any one of the where only a portion of the property or only few properties are situated. But in that suit, I have to include properties which are situated in other places also, as I told you, like Mandya or Mysore, and file a composite suit in respect of all the properties situated in Bangalore, Mysore, and Mandya in Bangalore itself, or in Mysore, or in Mandya, wherever I prefer. I like to file. I will have a choice to file either in Bangalore or in Mandya or in Mysore. But only thing is, wherever I file, I have to include all the properties situated at Bangalore, Mysore, and Mandya. So the proviso says that in respect of the valuation of the subject matter of the suit, the entire claim is cognizable by such court. What do you mean by this? So for the purpose of valuation as per the provisions of the Court Fee and Suit Valuation Act. I have to take the value, I have to value all the properties situated in all the places together, and the court where I am going to institute can take cognizance of the entire case filed in respect of all the properties situated in different areas. So this is so far as section 17 is concerned. In this context, we may also refer to one judgment of the Honorable High Court of Karnataka, reported in ILR 2010, Volume 2, Karnataka, page 1682, in Mahadev Swami and another versus Ramachandra. In case of suit relating to immovable property, I'm reading out the colored out portion from the judgment. In the case of suit relating to immovable property, suit must be filed within the local jurisdiction of the court where the property or properties are situated. Where there are more than one property and they are situated in local jurisdiction of more than one court, Section 17 CPC provides for filing of a suit in any one of the places in which property is situated. If most of the properties except one, those situated within the jurisdiction of one court and one item in another court, that another court also will have jurisdiction to entertain suit in respect of all the properties, though they are situated in the jurisdiction of different courts. ILR 2010, volume number 2, Karnataka, page 1682, and you may also see AIR 1988, Supreme Court, page 1347. Now we will move on to section 18. Place of institution of suit where local limits of jurisdiction of courts are uncertain. Subsection 1. Where it is alleged to be uncertain within local limits of the jurisdiction of which two or more courts any immovable property is situated, any one of those courts may, if satisfied that there is a ground for the alleged uncertainty, record a statement to that effect, and thereupon proceed to entertain and dispose of any suit relating to that property, and its decree in the suit shall have the same effect as if the property were situated within the local limits of its jurisdiction. How shall we interpret this? The reading of section 17, subsection 1 of section 18, according to me, shows that first of all, there should be an uncertainty as to within whose within the court of which jurisdiction will have power to entertain this suit. If a property is situated in such a manner which gives a reasonable doubt as to whether the court situated in place A has got jurisdiction over it, or a court where situated at place B has got jurisdiction, and if that uncertainty is reasonable, then I can file a suit either at place A, or either before the court at A or before the court at B. But in the plaint that I am going to file, I must make a clear statement as to what are all the grounds that have made me to believe that it is uncertain. So unless those grounds are properly narrated in the plaint, the court may not be in a position to appreciate the stand of the plaintiff about the reasonableness of that uncertainty. So once the court is satisfied that the plaintiff has every reason to have that uncertainty about the jurisdiction of a particular court, then the court may record the reason and entertain this suit. Look at the last 3 lines of this subsection. So once the suit is entertained by the court by making such a record and proceeded with and ends in disposal and a decree is passed, then the law says, thereupon proceed to entertain and dispose of any suit relating to that property, and its decree in the suit shall have the same effect as if the property were situated within the local limits of just jurisdiction. So, if the jurisdiction is uncertain, and if that uncertainty, the grounds upon which that uncertainty is entertained is reasonable, and if the court is satisfied about that reasonableness, and a record and a reason to that, and a record of that reasons have been recorded, and the court proceeded with the suit, and that ends up in a decree, either this way or that way, and that decree is deemed to be a decree passed by a competent court. So even if it is turned out later that there is something wrong, it will not affect the decree because all the ingredients of subsection 1 of section 18 have been complied with. So therefore, the compliance of the ingredients of subsection 1 of section 18 is very much necessary before a suit could be made entertainable by the court, and the grounds upon which the uncertainty is prevailing must be reasonable, it should be genuine, and there must be a statement to that effect. Provided that the suit is one with reference to which the court is competent as regards the nature and value of the suit to exercise jurisdiction. What do you mean by this? The meaning is, supposing the property in respect of which I want to file a suit has to be filed before the civil judge court. It is the civil judge court which has got jurisdiction to deal with the property, to deal with such property, and it is the pecuniary jurisdiction of the valuation of the suit also falls within the pecuniary jurisdiction of the civil judge court. It is only then that a suit filed either before the court at A or before the court at B would satisfy the requirements of subsection 1 of section 18, provided other ingredients of subsection 1 of section 18 are satisfied. Then subsection 2, where a statement has not been recorded under subsection 1 and an objection is taken before the appellate or revisional court that the decree or order in a suit relating to such property was made by a court not having jurisdiction where the property is situated, the appellate or revisional court shall not allow the objection unless its opinion that there was, at the time of the institution of the suit, no reasonable ground for uncertainty as to the court having jurisdiction with reference thereto, and there has been a consequent failure of justice. How shall we interpret this? According to me, subsection 2 says, let us say, for example, that at the time of filing a suit, the plaintiff was uncertain whether the suit was to be filed before the court at A or before the court at B. Of course, both the courts are competent so far as the subject matter and the pecuniary jurisdiction is concerned. So the plaintiff prefers to file a suit before the court A. And in the plaint, he also makes a statement about the reasons for uncertainty, the grounds upon which it was uncertain as to whether the suit has to be filed before the court, for A court or B court. And the court is also satisfied that the reasons recorded in the statement made by the plaintiff in the plaint is acceptable and it is reasonable, and also records the reasons for that in the order sheet, and entertains the suit, proceeds with it, and passes a judgment. Thereafter, if an appeal is filed by the aggrieved party, maybe of course the defendant, and if in the appeal where the statement has not been recorded under subsection 1, so if the trial court has not recorded the statement as required under subsection 1 of section 18, and an objection is taken before the appellate court or the revisional court that decree or order in a suit relating to property was made by a court not having jurisdiction, so the defendant takes up a contention before the appellate court that the trial court has not recorded the reasons to satisfy itself that the grounds upon which the uncertainty prevailed was reasonable, and proceeded with the matter, though the trial court had no jurisdiction. Then what the appellate court should do? The says that the appellate court or revisional court shall not allow the objection. So the appellate court cannot allow the objections to be taken unless, in its opinion, there was at the time of the institution of the suit no reasonable ground for uncertainty as to the court having jurisdiction with reference thereto, and that there has been a failure of justice. So unless the appellate court is satisfied on these two aspects, number one, when the plaintiff has chosen to file a suit before the court at A, there was no uncertainty at all prevailing that the suit ought to have been filed before the court at B. So even though there was no such uncertainty, the plaintiff has chosen to file the suit at court A. That is number one. Number two, both the courts are competent, both on the subject matter as well as on the pecuniary jurisdiction. Number two, if on account of filing of a suit at court A, if there is a failure of justice, then only the appellate court can entertain such an objection as to the jurisdiction and not otherwise. This is, according to me, how subsection 2 of section 18 will have to be interpreted. Then we will move on to section 19. Suit for compensation for wrong to persons or movables. Where a suit is for compensation for wrong done to the person or movable property, if the wrong was done within the local limits of jurisdiction of one court, and the defendant resides or carries on business or personally works for gain within the local limits of another court, the suit may be instituted at the option of the plaintiff in either of the said courts. Sorry. If a wrong to a person or to a movable property has been done at one place, let us say place A, but the defendant is residing at place B or carries on business at place B and works for gain, then the option is given to the plaintiff to file a suit for compensation or damages either before the court at place A or before the court at place B. This is so far as a compensation or damages claimed for a wrong done to the movable property or to the person. In this context, I think I can cite one judgment of the Honorable High Court of Karnataka, reported in ILR 2002, Volume 3, Volume 3, Karnataka, page 3384. Prakash G. Knott versus Chandini Knott. Chandani Court. Family Court, Pune, granted maintenance under Section 26 of the Hindu Marriage Act of 1955 in a matrimonial proceedings. Wife and minor daughter are residing at Bengaluru. Suit for maintenance of minor daughter under Section 20 of the Hindu Adoption and Maintenance Act 1956 filed before the family court at Bengaluru. Objection was taken as to the maintainability so far as the filing of the suit at Bengaluru is concerned. Held. Since the respondent and her mother are residing at Bengaluru, they can maintain a suit at Bengaluru Family Court as provided under Section 19 of the Act. This is so far as Section 19 of the Code of Civil Procedure is concerned. Then coming to Section 20. This is a very, very important section according to me. Other suits to be instituted where the defendant resides or cause of action arises. Subject to the limitations aforesaid, that is, keeping in mind the provisions from Section 16 to Section 18. If there is a suit which is not covered under any of the above said provision, subject to the limitations aforesaid, every suit shall be instituted in a court within the local limits of whose jurisdiction A, the defendant or each of the defendant where there are more than one at the time of commencement of the suit actually or voluntarily resides or carries on business or personally works for gain. That is where the defendant resides. Or any of the defendant where there are more than one at the time of the commencement of the suit actually or voluntarily resides or works for gain, provided that in such case either the leave of the court is given or the defendant who do not reside or carry on business or personally work for gain, as aforesaid, acquiesce in such institution. So where there are number of defendants and the defendants are residing in different places, and if a suit is and if the plaintiff wants to file a suit in one place where a particular defendant or a few defendants are residing, then he has to either take the permission of the court or the other defendants must acquiesce, means agree. So there should not be any difficulty in interpreting so far as clause A and B is concerned. Coming to clause C, or the cause of action wholly or in part arises. This is a very important clause according to me. This takes us to analyze and understand what do we mean by a cause of action. Without there being a cause of action, there cannot be a suit. Order 7, Rule 11 CPC specifically says the circumstances under which a plaint can be rejected. That particular provision says that the court can reject the plaint when, number one, when there is no cause of action. A, there are 5 grounds set out. The first ground is where there is no cause of action. So if the plaintiff does not disclose cause of action, then the plaint will have to be rejected as required under clause A of Order 7, Rule 11. Now, what is cause of action? Cause of action can be described as a bundle of facts. A bundle of facts. If admitted by the defendant, plaintiff is entitled for a decree. If denied by the defendant, the plaintiff has to prove. This is one raw definition that can be given. But let us see what the Honorable Supreme Court has said. In AIR 2001, Supreme Court, page 426. Every fact, what is cause of action? Every fact which if traversed, it would be necessary for the plaintiff to prove in order to support his right. So the plaintiff avers something in the plaint, the defendant denies. Though the burden is on the plaintiff to prove in order to support his right to a judgment of the court. In other words, a bundle of facts which is necessary for the plaintiff to prove in order to succeed in this suit. So the plaintiff, if at all he wants to succeed, he has to prove the facts which he has averred in the plaint when it is denied by the defendant. This is one definition. In fact, in another important judgment of the Honorable Supreme Court, reported in 2009, Volume 7, Supreme Court Cases, page 768, Kandimalla Raghavan versus National Insurance Company. The Honorable Supreme Court has said, while referring to the term cause of action as under, quote, the term cause of action is neither defined in the code or in the Limitation Act, but it is of wide import. It has different meaning in different contexts. That is, when used in the context of territorial jurisdiction or limitation or the right to sue. Generally, it is described as bundle of facts, which if proved or admitted, entitle the plaintiff to the relief claimed prayed for. Cause of action is the cause of action which gives occasion and forms the foundation of the suit for which the suit is brought. So according to this, the cause of action could be looked from 3 angles. One is with regard to territorial jurisdiction. The defendant may say, sir, none of the facts narrated in the plaint have taken place within the jurisdiction of this court. So no part of cause of action has arisen within the jurisdiction of this court. Therefore, there is no cause of action and therefore this court cannot entertain this suit. Or there could be a limitation. The suit that is filed is barred by limitation and therefore there is no cause of action for the plaintiff to come up with this suit. Therefore, the suit is not maintainable for want of cause of action. Or the defendant may take a contention. The plaintiff has no locus standi to file this suit. He cannot seek the relief that is claimed. There is no cause of action in his favor to file this suit. Therefore, the suit is not maintainable. So, what I mean to say is, if this judgment is looked into, the cause of action is of a great import, which can be looked into from all the three angles. Number one, from the point of territorial jurisdiction. Number two, from the point of limitation. Number three, from the point of right to sue. All said and done, again, the Supreme Court has said in this decision that cause of action is described as bundle of facts, which if proved or admitted, entitle the plaintiff to the relief that is claimed or prayed for. Cause of action is the cause of action which gives occasion for and forms the foundation of the suit for which the suit is brought. So unless being a cause of action being a foundation, unless there is a foundation, there cannot be a plaint. In another judgment of the Honorable Supreme Court reported in 2020, Volume 4, KCCR, page 296, short notes. The word cause of action has been defined as cause of action means every fact which would be necessary for the plaintiff to prove, if traversed, in order to support his right to judgment. It consists of bundle of material facts which are necessary for the plaintiff to prove in order to enable him to the relief claimed in the suit. Thus, cause of action is a must in a plaint. Without there being a cause of action, there cannot be a plaint. As I have already told, Order 7, Rule 11, Clause A says that if the plaint does not contain cause of action, it can be rejected. So cause of action is the foundation in the suit. Now coming back to Section 20, Clause C, where the cause of action has arisen either partly or wholly, or in whole, or what is the word? Cause of action wholly or in part. What do you mean by this? Even a fraction of a cause of action has taken place in one place, and the major part of the cause of action has taken place in another place. Even the court where the fraction of a cause of action has taken place has got jurisdiction to try the case. That is the meaning of saying the cause of action either wholly or in part arises. To understand this, I think I can give 2 or 3 citations. In 1979, Volume 2, Karnataka Law Journal, page 410. A contract is complete when the offer is accepted. It is the acceptance of the offer that gives rise to a cause of action and not the place where the offer is made. So a contract to be a concluded contract, there must be an offer and acceptance. Mere place where the offer is made, that place, there no cause of action arises in that place unless it is accepted by the other party. So the cause of action arises only when the offer is accepted. For example, offer is made at Mysore. Contract is accepted at Bangalore. So the court which is situated at Bangalore, the cause of action arises within the jurisdiction of Bangalore, and the court situated within the jurisdiction of Bangalore has got power to entertain the suit, place of suing. In a suit for contract, I am referring to AIR 1989, Supreme Court, page 1239. In a suit for contract, the cause of action will consist of making a contract, its breach at a place where it has to be performed, and other facts. Therefore, a suit for breach of contract can be brought either at the place where the contract was made or at the place where the contract was broken. In ILR 1982, 1 Karnataka, page 804, in a case of a contract by correspondence, P calls for quotation at Bhadravati, D submits offer from Bhadravati and paid amount through bank draft drawn on bank at Bhadravati. Therefore, the court at Bhadravati has got jurisdiction. So that is so far as Section 20 is concerned, where the cause of action arises either wholly or in part. Just I have one judgment which says that you are a fractional. 1 minute. Just 1 second, please. An agreement by the parties boosting the jurisdiction of the court is unlawful. Supposing the court which is situated at a particular place only has got jurisdiction, then there cannot be an agreement between the parties ousting the jurisdiction of that court. It will be unlawful because it is against law. AIR 1989, Supreme Court, page 1239. When there is more than one court having jurisdiction to entertain such a particular suit, a particular type of suit, then there could be an agreement between the parties confining their dispute only to a particular place where the court, particular court having jurisdiction. If two courts situated in two different places have got jurisdiction, by agreement of parties, the parties can concur to raise their disputes, if any, before any particular court which has got jurisdiction. AIR 1992, Supreme Court, page 25-24. Yes. In AIR 1965, Mysore, page 316, part of cause of action mentioned in section 20C includes even a fraction of cause of action. The magnitude or percentage of cause of action is immaterial. So this is so far as section 20 is concerned. Hello, Mr. Vikas, sir. I think we have to cover only from 15 to 20, isn't it?
Yes.
15 to 20, isn't it?
Yes, sir.
Okay.
Thank you for sharing.
Just I'm referring to 2 or 3 citations. You can make a note of it if you want. One is 2001, Volume 2, Supreme Court Cases, page 294. 2001, Volume 2, Supreme Court Cases, page 294. Rajasthan High Court Advocates Association versus Union of India and others. In this judgment at paragraph number 17, the Honorable Supreme Court, referring to the earlier judgment reported in 1995, Volume 4, Supreme Court Cases, page 738, UP Rashtriya Chini Mill Adhikari Parishad versus State of UP, has observed thus: the expression cause of action has acquired a judicially settled meaning. In the restricted sense, cause of action means the circumstances forming the infraction of the right or the immediate occasion for the action. In the wider sense, it means the necessary condition for the maintenance of the suit, including not only the infraction of the right, but the infraction coupled with the right itself. Compendiously, the expression means every fact which it would be necessary for the plaintiff to prove, if traversed, in order to support his right to win the judgment of the court. every fact which is necessary to be proved as distinguished from every piece of evidence which is necessary to prove each fact comprises in cause of action. It has to be left to be determined in each individual case as to where the cause of action arises. Then there is 2007, volume 13, Supreme Court cases, page 650. In Subhash Mahadevsa Habib versus Nemasa Ambasa Dharmadas, led by LRs. Then 1966, AIR Supreme Court, page 634. Bharin Petroleum Company Limited versus PJ Pappu. So that is all. Thank you very much. Thank you for having provided me this opportunity and also for giving a patient listening to what I said. Thank you very much. Thanks, Mr. Vikas Shetrat, sir.
Thank you, sir, for sharing your knowledge.
Now that you cannot unmute yourself, nor any person can talk. Anything else to say?
Thank you.
Thank you. Thank you very much. All the very best.